Madam Chair, it is 5:30.
How do you like our DJ? Good evening, everyone. I'm going to call this meeting of Planning and Zoning to order. We're going to start with the roll call, Shelby.
Yes, ma'am. Jim Drew.
Here.
Daryl Whitworth.
Here.
Jeff Lawrence.
Here.
Cindy Scroggins. Emily Kirchner. Here. Holly Rickard. Here. Tim Dooley.
Here.
Steve Thomas.
Here.
Janice Menking.
Here. All right, thank you. Let's go on to item number 4, public comments. We'd like to give anyone who's here a chance to make public comments about items that are on the agenda or are not. Limit to 3 minutes to speak, so if anyone has anything to say, please come forward now. All right, anybody online?
No, ma'am.
All right, thank you. We will go on then to item number 5. Public hearing 5A. A public hearing regarding request Z2206 by John Zuck, applicant, to consider a conditional use permit for section 3.510 to construct 2 first-floor bed and breakfast units in the historic shopping district overlay on property located at 403 Austin Street. I'll entertain a motion to open the public hearing.
I'll make that motion.
Motion by Jim. Do I have a second?
Second.
Second by Polly. Any discussion? All in favor, aye.
Aye.
Opposed? All right. Is Mr. Zook here to make a presentation? There you are. Thank you. You'll come up here and let us know about your project. Thank you. We'll see if anyone else has comments, and then we'll close the public hearing and we'll get with you if you have questions. Thank you very much. Is there anyone here who wants to make any comments on this request?
I move to go out of public hearing back into regular session.
Second.
Motion by Tim, a second by Jim. Any other discussion? All in favor, aye.
Aye.
All opposed? All right, thank you. Shelby, you making this presentation?
Yes, ma'am.
Okay.
So as Mr. Zook mentioned, he submitted an application for a conditional use permit. Better?
Better.
Awesome, thank you. And this is a requirement because his property is located in the historic shopping district. You'll notice in the application that Mr. Zook submitted this application February 25th. So it came in prior to the adoption of the new short-term rental ordinance. So it was reviewed under the 2018 short-term rental ordinance. As Mr. Zook mentioned, there are 2 existing units, and they're proposing adding 2 additional one-bedroom units. They are found to be in compliance with all of the city's requirements. They've actually exceeded the parking requirement under the 2018 ordinance. They're required to provide 4, and they provided 10. That does include 1 ADA unit and one ADA parking space. There is some requirement for landscaping that will be reviewed as part of the landscaping plan. And there is a requirement for screening, which they've provided. There's some existing screening. There's a 6-foot privacy fence provided along the western property line, and existing privacy fences along the southern and the eastern property line. So we'll just construct the western portion to complete that privacy fence as is required, and everything else looks great. There's also a requirement for Parkland dedication fees prior to the issuance of building permits at $500 per unit. So it'll be a total of $1,000 for the additional 2 units. Staff recommends approval.
Thank you, Shelby. Anyone have any questions or comments on this? Yes, ma'am.
Are there any planned current or future hot tubs to be put on the property? Okay, and if that changes where they want hot tubs, would it have to come back for approval? Because isn't this conditional use? So if they change it, do they have to come back for a new conditional use approval if they add hot tubs? Can we make it a condition that they
Somebody
not,
going to answer over
Everybody's
there.
can we make it a condition of the
We're looking
approval
at
that they
all
not put hot tubs on the
So
property?
this is sort of a limited conditional use permit. The
Mhm.
criteria is just the first floor B and B in the historic shopping district. And so there's specific criteria that P&Z is supposed to consider. I don't know that it involves site plan as much as like how it interacts with the surrounding
Right.
properties and does it
Right.
contribute or detract from the historic
So
shopping
I'm looking
district
at like what we did on South San Antonio where we had them reorient where the hot tubs were centralized and away from the perimeter because they had commercial on one side, but they had R1 and R2 adjacent on the other sides. And I'm looking at this one individual who's on one side who is actually using it as a residence, even though it's in a commercial zone, that the addition of hot tubs to the property without some sort of review of where they're placed would cause a nuisance to the neighbor. And so I know we've considered nuisance factors in the past when we approve these and put conditions around nuisances. So that's why I'm asking.
I think if that's a concern of the commission, that you probably could make that a condition of the approval that, address that topic as part of your approval. Obviously, the addition of a hot tub or hot tubs could alter your analysis of how it would impact the surrounding properties.
So we could sort of put in a recommendation before that. Hot tubs are added, follow the new code.
Or just saying we're approving it.
And Ms. Polly, you alluded to it, but for the record, I would like to add that staff did receive 1 protest for a property owner that resides at 108 North Milam, Mr. Carson Dickey.
Now, the good news on that property, it's next to the driveway, so there's gonna be some spacing. But again, like we've considered those nuisance factors in the past, I think we need to consider that one here because it is pretty tight.
I have a question on the impervious cover. So it says it's 38% and it looks like there's a lot of homes and parking. So is it gravel and is that considered pervious? It's 1/3 of an acre, but I mean, I'm not seeing a whole lot of green space. It's the 4 houses and parking.
So because it is gravel and it's not any sort of fire lane or anything like that, it would be considered pervious.
Any other questions?
I move we approve it as presented.
Quick question
Oh,
first.
I thought there
wait
was-
just a moment. Jeff has a
Do we,
question.
do we add in the fire pit question to it as well, or not?
Consider fire pits. Fire pits create the same kind of nuisance as hot tubs.
What do y'all- If we're gonna do the hot tubs, might as well do both.
I agree with that. Same thing, just different venues.
Right.
All right, anybody ready to make a motion? Any questions?
His motion was to add the fire pits in the hot tub as a restriction that requires reconsideration of conditional use.
So who's actually making this motion?
He is. I'll take that.
Do you have
Second.
that motion down, Shelby?
Motion to approve conditioned upon no hot tubs and no fire pits made by Jim Juro.
Or.
Yeah.
It has to be conditional.
Is that allowed, Daniel, is that allowed, or do we just say no hot tubs, no fire pits?
Give me just a second. I'm looking at the ordinance right now, trying to give a little more specific guidance on
Give
what,
you a few
what action you can
minutes.
take. So there's nothing that specifically addresses this issue, but you have pretty broad authority to place other reasonable conditions upon the application that would promote the goals of the ordinance. And it's fairly broad. So you can use your discretion to, so if you want to curtail a certain use, I think you would have the ability to do that or limit the way that it's used, hours of operation, things like that. So I'm sorry, I didn't hear what the question was or what was being proposed.
No, that's clear. So do we want to go with just no? And then leave it at that? Because that's more clear than saying you can come back. Okay. You want to restate your motion too?
So, approve the conditional use permit with the two exceptions, hot tub and fire pits.
All right, so I have a motion for action item number 6A,
Second.
and by Jim, I have a second by Paul. Any other discussion?
I think that's gonna be a more palatable removal of the city council.
All in favor, aye?
Aye.
All opposed? All right. Thank you, Mr. Cook. Zook. Say Cook. Zook.
Zook.
All right, let's go to action item number 6B. Request site plan 2205 by Garrett Keller with Matkin Hoover Engineering to consider a multifamily development, Orchard Grove Phase 2, located at 1602 North State Highway 16. He's ready. Thank you. Okay.
We are proposing. I'll just kind of give you a little breakdown. We sort of look coupled with what we see. Feel like that's Which one's Orchard Grove? Is that the one accessible off the road, Crab Apple? Both those are there.
Okay, thank you. We'll see what staff has to say, and then we might have some questions. Thank you. Garrett? Yeah, this one.
Yes, ma'am. So you did a good job of covering the basics of the site design. Again, it is 80 total units. They are providing adequate parking spaces. There's 112 required, 114 provided. Access will be via the existing Orchard Grove development to the northwest. And then they're also proposing a new driveway onto Lower Crabapple Road. We have been working closely with them, and they are lining it up with Cross Street, which really isn't an existing street, but that would be a proposed intersection in the future, possibly. The other thing I wanted to mention is there is an ongoing drainage issue in this area, particularly with the Escamias to the south. So we had been working with the previous engineer, the McDonald Company's engineer, trying to address that. When they purchased the property, they brought on Matkin Hoover, and they've been very good to work with. I think we've come up with a solution that will address most of the issues. There is still going to be some runoff draining towards Escamias, but that's primarily from TxDOT right away. So that needs to remain in place. But the majority of the runoff will come out of a redesigned detention pond and drain via a storm sewer line that will go across Lower Crabapple Road into that existing channel. Another thing I wanted to mention is they are proposing a sidewalk in accordance with the adopted city sidewalk plan that will run up along North Llano. So we'll need to work with TxDOT for approval of that. But overall, everything appears to meet applicable city codes. So staff is recommending approval with a number of conditions in the memo. The first being approval of a landscape plan. The second being approval of civil construction plans. The third being TxDOT approval for any work in state right of way. As I mentioned, they'll need to approve the sidewalk and any drainage or grading improvements. And then Parkland dedication fees.
All right, thank you, Garrett.
So y'all gonna build a
Questions?
bridge over the current detention pond and make Cross Street go right over?
It'll basically be regraded. So the detention pond will be on both sides of the driveway, and there will be a storm sewer pipe running under the roadway. Very similar to Orchard Grove Phase 1. They've got a very similar design.
Would it be a fair question to ask what kind of price points you folks are shooting for? Please, yes. Do you have any efficiency in either one of the other unit? For the efficiency? Okay.
So something along there between highway 16 and development. Sidewalk. We do have done and being dominant in the project done here in our all plant document. So, the original well, I can't do both. Why would we work in what is this property?
C2.
I have a question on sidewalks. It's great that we have something on 16. Is there also going to be anything along Lower Crabapple? It is.
Yeah, it'll wrap around both frontages.
Okay, thanks.
Anyone else?
Motion to approve 8.201 with the following conditions, approval of civil construction plans. The exact lot acreage should be noted on the plat.
That's a different,
That's a different.
yeah.
Go back to B.
Go back, page 15 and 16.
You can say as presented. As presented. I'll get it. I was just gonna try it.
Oh, you show them you can read.
Yeah. Landscape plan, approval of construction plans. Checks out approval of right of way. Kitchen floor.
Second.
Okay, I have a motion by Jim, a second by Tim. Any other discussion? All in favor, aye.
Aye.
All opposed? All right. Carry on.
You can just
Thank
keep
you.
the deer from crossing over from the cemetery, so I don't hit them on my motorcycle. That's why I asked about the fence, so.
Do you have any restrictions about deer feeders in the backyard? He has one.
You're not helping.
Thank you. Thank you very much.
Thank you.
See you, Peter.
All right, let's go to action item number 6C, request P 2216 by Kevin Spraggins with VEI to consider a final plat for the Prospect subdivision located at the intersection of Homing Lane and Friendship Lane. Mr. Spraggins, you are up. Thought you were asleep.
Yeah. I get through the conditions.
Yeah.
So this is a final plat for what we call, now it's called the Prospect. So this is a continuation of what we've been. Into all the I think that break. entertain so the only real difference between instead of dedicating the right of way, we're just then other than that,
All right. Thank you, sir. Got any more comments, Garrett?
Mr. Spraggins did a great job of touching on everything. Just to provide a little more information regarding the roadway, right-of-way, or access easement. There's a lot of unknowns here, not necessarily with just Lot 3 and knowing how that's going to be laid out, but also across the road is the potential middle school site for FISD. So hopefully we'll know a lot more here in the next week or so on that. So in our discussions with Mr. Spraggins, we had said if that's going to be public right away, we need to see how that's going to be routed through phase 3. If it's a public street, we want to know where it's headed, if it's going to line up with Bob White Trail or not. So that's still an unknown. So I think this is the best route, just to dedicate it as a public road easement. If and when it needs to turn into a public roadway, as Mr. Spraggins mentioned, it'll be built to a city standard, so that shouldn't be a big deal. But other than that, the biggest change from the preliminary plat that y'all approved back in February is Lot 3 has been added into the final plat. So although there isn't a known use, the entire subject tract is now part of the plat. So staff does recommend approval. There are a number of conditions on this one as well, which include civil construction plan approval, including any required traffic impact analysis. We do anticipate this triggering the need for a TIA. We also want to have the exact lot acreages noted on the plat. Right now it's plus or minus, and payment of Parkland dedication fees associated with the development.
All right, thank you.
It's 1,000 trips per day, so it varies based on if it's residential development or commercial. But I don't know the exact unit count that's being proposed, but okay, so it'll be part of the civil construction plan review. We'll take a look at the TIA.
All right,
Who owns
thank you.
this property and are they the developers?
So who owns the properties?
Who owns the property and is lot 1 and lot 2 owned by one party and lot 3 owned by another? Okay. How they gonna get there? Is there, I know, but, okay, so they don't propose any kind of entrance onto lot 3 right now, anywhere?
It'll be off of homing.
Yeah, so what they want to do is they want to make sure they still have access.
Understand,
So that's why they're running.
understand.
So they have full frontage, secret lot group that still has full frontage.
I understand.
So now you have, remember, the development, they have 2 instances of now they're going to now that's
Mhm. Mhm.
Still have lots of regulation. Got whatever free, yeah. Here's what I-
Right, but, and the city can require them to line it up with Bob White?
It will need to meet the applicable spacing requirements at the time of development. So it doesn't necessarily have to line up with Bob White, but if it doesn't, it will have to be further south,
Mhm.
you know, to provide adequate spacing.
Understand, okay. I mean, we're one step away from knowing where both of those access points are gonna be on Homey. I mean, one's an obvious, and the other one, I guess, is whatever they can fit in.
Yeah, if they don't pop,
Yeah, understand.
how many units is this projected to have?
So Kevin, lot one is gonna be 55 and up, right? Is that gonna be restricted? Big picture, are we able to change that in the event that the middle school gets built and there's more of a need for multifamily and not just senior living? Okay.
They are building.
Thanks.
Is this currently in that proposed site?
Yes. Yep.
This-
Anybody more questions? Anybody ready to make a motion?
I've already done that. Make a note, we approve final plat.
Second.
Motion by Jim, a second by Tim. Any other discussion? All in favor, aye?
Aye.
All opposed? All right, sir. Thank you.
Let's go.
Thank
you.
Certainly.
So tonight, based on assuming Frank just put another 40, 50, 60, whatever units, we effectively approved $60,000 to $80,000 park dedication fees. Remind me where the hell these things are going, used for, in a big old safe. I mean, it's a little bit said in humor, but also we've done this for a lot of times, and probably remiss on my part not to know exactly, but then by the same token, I don't know that I can recall ever being shared. This is what we're going to do with this money structure.
It's been a while. I mentioned that.
Yeah, we've talked
This
about it.
afternoon.
I think that'll be part of the comp plan update, you know, looking at future parks, but I know that's a ways out too. We are looking at some potential improvements to the city-owned property on Friendship Lane near the big regional detention pond. So east of South Washington on the north side of Friendship. Looking at potential development of that. There are some things being discussed, but I don't have any specific plans to mention to you. But it is going into a fund, so I can try to get you an update on the balance of that, but I'll have to talk to finance.
Please don't take this in a negative light, although it's going to come out this way. After 25 years of being involved with the city and the hotel tax fund, where things suddenly go into this vacuum and kind of like disappear, be nice to maybe get an idea of what's there, since we, as the commission, had been the ones saying you have to put it in there, then followed by council. So, but that may be something we can discuss on the next time.
Yeah, I think that's actually a good segue.
It was not planned that way, but I started doing some math. and it did. That's, you know.
All right, let's approve the minutes and then we'll go to item number 7. So let's go to item number 3.
She always finds something.
It's all right, let her do it.
Did not find any errors, other than formatting, is that fine? It doesn't matter in terms of needing to have the seal or anything. Otherwise, I think it's fine to approve. I move that we approve the minutes from April 6th, planning and zoning.
A motion by Emily, a second by Jim. Any discussion? All in favor, aye. All opposed? All right, those are approved. Then let's go to item number 7, discussion item 7A, discuss process and policy related to planning and zoning meeting agenda. Daniel, is that you?
That's me. So after the last meeting, I started digging into state law, our ordinances, city charter, and I found, kind of piece everything together. Found some interesting things. So state law says that this commission is subject to the Open Meetings Act. I think we all agree with that, but it's clear that there's no question there. We actually have a section in our planning ordinance that, among other things, says that this commission has the power to make rules, regulations, and bylaws for its own government. The only restrictions are that those rules should conform as nearly as possible to the same rules that govern the city council, and the rules are subject to approval by the city council. So that can include things like the minutes that we just talked about, like the form of the minutes. You could develop rules or regulations for how you want those to look, how things are put on the agenda, who prepares the agenda. If you want to require like annual reports to council or something like that. So the short answer is that you do have the ability to make your own rules and regulations and bylaws for how you all operate. We need to try to match those or align those with the council's rules, and they're subject to council approval. So I brought an example on the issue of the agenda, which is what we were talking about at the last meeting particularly. So right now, the council's rule on agenda says that the city manager shall prepare the agenda. So you could adopt something that says maybe the director of development services prepares the agenda for your meeting. And then topics on the agenda are added at the city council level. They're added when they're deemed appropriate by the city manager at the discretion of the mayor, or as directed by at least 2 city council members. 2. So that if the commission was interested in adopting something similar, you could say, items or topics are added to the agenda when deemed appropriate by the director of development services at the discretion of the chair, or as directed by any specific number of members of the commission.
So Holly and I can get together before the next meeting and just ask to have it put on. Or does it need to be approved at a
Right.
meeting for the next meeting?
So what, no, it would be, you would communicate that to the director of development services or whoever's tasked with preparing the agenda. And as long as the criteria is met, if it was tasked to be the chair, you could put something on, or you'd have 2 or 3 people, however many you want, could agree, and you actually have a form that the council uses sometimes, but we can do it by email also. If you have a certain number of people concur to put something on the agenda, it would be added. So you wouldn't have to come here and talk about it, put on your next agenda. You could do it in between meetings.
Do you have to include the director of development services in that? Must we get the approval of the development director to put something on the agenda or not?
No, the way that I interpret it, it's any of those 3 options. So the director could put it on, or chair could put it on, or concurrence of certain number of members could put it on. And
Can anybody take it off if we propose to put it on?
I don't think so. Not the way that this is written. I wouldn't interpret it that way.
Okay.
So there's nobody that kind of has an editing authority to pull something back
I
off the
understand.
agenda.
Okay, that's important.
And
I would expect that the standard rules would apply. So if an item comes on and we agree that we want to table it, then we can make a motion to table it. If it's something that we're saying we don't want to
Right.
discuss or we're not prepared
There's
for.
no shot clock.
Right, or that kind of stuff. We don't fall under shortcut unless it's one of the state limit.
Right, yeah, that's only on certain types
Wait a
of
minute, wait a minute.
actions.
My understanding of when you table something, it's dead. Once you table something, it's dead. Okay, it's not like, when I was on council, way back, to avoid that, what you did was just take no action. Is that the preferred procedure, Daniel, or
Well,
or is that the
so
way to get around it?
that's something that could be included in your rules is do you want to adopt Robert's rules, you know, for your procedural questions that aren't clear?
Or can we make our own?
Right. I mean, you could adopt like 5 or 6 like specific kind of keywords, like, you know, table of motion means this. If you want to
Okay.
kind of identify some of the commonly used terms, you could do that.
Okay.
I just was no question.
I think that would be a valuable conversation for the training workshop that we do, that covering things like how much of Robert rules are we going to adopt and use? What are our little shortcut words that we can use to either table something, defer something, or just kill something that is brought up? Those types of things I think would be important for us to discuss and then codify as we move forward so that it's clear to the public too when we use those terms. Somewhere it's written that this is what we're doing, and so they don't get confused by us saying we're going to table it versus take no action. Those types of
The other thing that comes to mind is where would these fall in the actual agenda?
Would be a discussion.
Yeah, I mean, there will,
Probably.
there could be some where action's required, so it would be an action item. There's others that might just be discussion topics where no action's required. I think that there again, it's important to define the roles and responsibilities of the board through this training session.
Also, the staff reports, if you wanted like kind of wanted to specify a specific format for those or specific information that you want to be in those, so there's consistency.
Okay.
You could do that as part of this process. Even the order of business on your agenda can be in those rules. So if you want to always have like a certain order of, you know, and we kind of do that, I think, already by custom, but if you wanted to include that in the rules, you could. So, you know, you really have sort of an open, I mean, as long as they conform similarly to the council's rules, you have a pretty open field as far as how much regulation and rules you want to adopt for the commission or not.
And like one idea for the work, when we do the training and workshop, is talk about, do we want to publish a planning and zoning annual report? Do we want to keep track of how much development, how many new units, how many residential units have we approved in the year, and then subsequently how many actually got built? So we start getting some idea of ratios between how much we are approving that goes out in the newspaper, and then 4 years later, how many units actually hit the ground. So we kind of have some idea, like on housing, are we getting ahead of the curve? Are we still behind the curve? You know, kind of where do we stand in terms of increasing supply of certain categories of properties that we need in our community? So
Brian,
those were thoughts that came to me about potential annual plan and annual report items.
Brian used to do that. Does he still do that for city council? Or was that still being done for city council?
Not really. So we are looking at a lot of these things for the city council as well. One topic Clinton and I have been talking about is having, you know, regular updates to council regarding development. And as we're looking at these things, I think each of the boards is supposed to provide an annual report to the council. So that's something we can talk about when y'all want to try to do that, you know, and if you want staff to prepare the report and y'all present to the council, or if staff just presents on behalf of the board. So happy to talk about all this stuff.
That may be an advantage to us, knowing what's coming down the pike and anticipating how much grief we're gonna get from the general public. Also, too, I think it's a little bit remiss that development review kind of operates in a vacuum. I mean, I've been screaming about parking at the Albert since the first time I heard about it. It seemed like that got missed somewhere along the way. So consequently, we're having to deal with a major cost parking situation. So that's just using that as one example. But I don't know if development review, is it happen weekly? I don't know if that's.
Yes.
Public knowledge, common knowledge?
Not
I
listed
know
part
our
of the
pre-app
process.
meetings are confidential because there hasn't been a formal submittal to the city.
I see.
So, I mean, we do bring forth everything in accordance with the ordinance. So the site plans that come before you are in accordance with the development ordinances. You know,
So that's where the fights are, basically. The give and take between staff and the developers, is that correct?
most of the time, yes.
Then
And again, we review
And
based on the
That's by design,
ordinances.
is it not?
Um,
That's by design. That why you have the DRCs? Is to flesh out the differences between the two.
correct. You know, we talk, when they come in, you know, we try to find major issues or flaws in the projects, and then we walk them through the steps. Okay, here's what you're proposing, here's what it will take to get approved.
I think part of what you're referring to, Jim, is
Bless 'em.
possibly flaws in our ordinances.
Well, that.
We got some holes
But
that,
also too, what he just described.
Right.
So unless we do a comprehensive study, number one, plan, number two, and then we look at all this to see how it's impacting us today versus the way it's impacting us last year. Those things are changing so rapidly. I just don't want those companies to, and I don't know how this piece of wood will be.
So I would guess those kinds of answers we would get after you get a new development director and the comprehensive plan is done, then you see what the next steps are beyond that.
That's a big part of the comprehensive plan. Again, it's not a quick fix because you have to look at everything. So it's going to be a process, but you know, hopefully in 18 months or whenever it is, we have a set of ordinances that are based on the kind of development goals of the city. Like I think that'll be one of the first questions is what are your concerns with current development? You know, what do you foresee coming down the pike that you're concerned with? And now let's look at each ordinance to try to address that.
One of the things that part of our last meeting was the potential for us to go into exec session. Flush that out at all, maybe?
That's really related to putting an item on the agenda. I mean, if you want to put something on the agenda and it's appropriate for an executive session discussion, then you can put it in an executive session.
There aren't that many things that you can go into executive session
Right.
for, though, really.
Right.
But there's
So,
things that we've approved that have been a topic of executive session for city council, but we aren't privy to those discussions. So that would be something that would be relevant.
So I say that again, Emily.
There have been things that we have approved on planning and zoning that have been the topic of an agenda item in the executive session.
For the council.
Right.
Yeah, annexation stuff.
So what things would go into executive session, for example? What would apply for us?
well, it's hard to say, but I mean, there's certain categories in the Open Meetings Act that are appropriate or allowed to have a closed room discussion. So it can be consultation with an attorney, either be about pending or contemplated litigation, or some other matter where there's attorney-client privilege for the discussion. It can be discussions on real estate matters, if just like purchase or sale of real estate, which I don't think that would ever really be an issue for this commission, but if there's a discussion of that matter would be detrimental to the city's bargaining position, you could discuss it behind closed doors. Personnel matters can be discussed I mean, it's fairly nuanced, but those are sort of the primary ones that you'll see.
I do have a question. So the development review, DRCs are confidential. Is there ever a need to bring a confidential matter in front of planning and zoning before bringing us the official to either test the water or get a view on it before it becomes an official thing out in the open? Because I can appreciate that in some cases you're running through DRC, there's still some questions you're really not sure how P&Z is going to land on it, nor council. Is that type of a confidential discussion that would come to us through an executive session or not? Or do we literally have to wait until it's full open meeting before we even see it?
session.
Yeah, so really, most of the stuff like lands on your agenda after an application is filed, and most of the discussion that you're referring to is before an application is filed. And so, other than sort of a general, sort of a theoretical discussion, I don't know that it would otherwise be appropriate to bring one of those.
I just didn't know if there was a need
Yeah.
for
I
the
can't answer
development,
that because
for development services to be able to come to us through executive session on certain sensitive things before a formal public application hits our door. And I'm just saying, think about it, not that you do it, I'm just saying, if it falls into one of those Open Meetings Act categories that we can do, I don't want to preclude development services from having that as a tool in their toolkit. So it's more for you guys to think about and
It
think
could
about
definitely
whether
be
there
beneficial.
are situations, because if we are going to utilize executive session as part of our agenda, I just want to make sure we're covering things that may ordinarily fall through the crack, things that you ordinarily wouldn't bring because we're always in open.
Yeah, that's the whole thing. It has to follow the Public Meetings Act. So, I don't know. We'll look into the possibility of executive session items, but
But too, is that staff recommendations typically are, again, just the minimum standards of codes. I don't see, is there any reason why y'all can't say, no, we need more parking for this project, whether it's in the code or not? And we sometimes don't recognize it. I'm really studying it now to see what's coming up for us. But is that against any regulations? Any recommendations?
I would say as a recommendation possibly, but if they come back and say, if the applicant comes back and says, no, we're meeting the ordinance, I don't think we can require above and beyond the ordinance.
Well,
Now, if it's conditional
we're in a
use or
warehouse
things
thing,
like that, I think that's the board's role or the commission's role and ultimately council.
Right, I've researched that because we've had that question before from a developer. And if they're doing something that doesn't require that doesn't give any discretion, it's not a conditional use permit or offsite parking or something like that. They meet the requirements in the ordinance. We can't require them to do more than that. But if they step into a situation where they're asking for a conditional use approval or offsite parking,
Or a PUD?
right, any of these things that give more discretion to P&Z and or the council, at that point, that's not applicable. So, I've had discussions with the developer and they were concerned about that. And my advice was, well, don't do anything that's conditional and you know what your parking is going to be, but if you're going to do something beyond that, you're subject to the discretion of the P&Z and council. So sometimes you can ask for more parking, sometimes you can't. So,
That's sort of what we ran into the Warren Warehouse moving
well, and also
back
that
behind Granite
Friendship
House
Oaks,
and all
the
that.
Friendship Oaks development.
Well, we've had
We
some-
didn't like it, but the ordinance said, they complied with the ordinance. There was
Well,
really anything we could do.
And putting on my engineering hat again. So from an engineering perspective, we always look at health and public safety. So when we condition approvals or when y'all condition approvals on civil construction plan review and approval, there's some things, if they're proposing a driveway, that's creating a star intersection or something to that effect, we can comment on that and not allow it. But as far as minimum standards with parking and different things like that, that might become a little more difficult.
Let me ask you this, this is a procedure question. I've always had this question. Why does it come to us?
I think that's the way the ordinance is drafted, that the DRC site plan comes before you. And so a lot of times the developer doesn't want to pay the cost to pay their civils for full design until they're comfortable that, hey, yeah, this is moving forward and it's acceptable. And there's a whole lot of that goes into this. They're going to try and do the minimum, spend as little money as they can, but they want assurances that the project can proceed.
And before they want to buy the property.
So on the meeting agenda item, is that something that we need to bring if we want to vote on a specific procedure for putting agenda items on our agenda, do we need to do a vote? Or is this something you can just prepare as a procedure and we just start using it? How does that work?
Well, I think that you will need to adopt something and then it will need to be approved by council. So if that's something that you want to move forward with, we could bring it, start working on a draft or something to bring to the next meeting or some future meeting for y'all to discuss and, reduce, edit read it how you wanted to read it, and then you can take it to council.
I think it'd be great if you just started with what the city council has, and that gives us a chance to look at it.
Okay.
Yeah, so maybe at the next meeting, you bring us the city council version and we can discuss any modifications we want that are pertinent to us and then adopt that as our procedure. So basically a copy of the way city council does it.
Well, if y'all are agreeable, I mean, we can put together a draft based on the guidance from city council. Maybe
That would
leave some
work too.
blanks as to how many members are required to do that. And then at least we'll have something to talk over. And then we can decide, is that acceptable to take forward to city council, or you want to make some more changes?
So maybe at our next month's meeting, we could finish, take the draft,
Mhm.
finish it in the meeting and take our vote, take action, send it to city council. That'd be great.
Has any of this ever come up with your board?
As far as rules and procedures, it's not as big of an issue. We usually add things as discussion items. We've never used executive session, but we often have discussion items.
I think maybe we have had an executive session for litigation, pending litigation. And that's really the only time I could really contemplate probably this commission having one. I mean, the most likely scenario would be pending litigation or legal advice, like if you need some advice on how something, with the code or how something's written that needed to be discussed that you didn't want to discuss openly, you could do that. But most of the other things wouldn't really be applicable to the commission. And also HRB has a little more detail in their ordinance as far as procedural stuff, I think, for their meetings, so that they're not, y'all are a little more open. There's not as much guidance for the commission currently, so, but you do have ability to adopt your own.
Would y'all be able to send us the references for the city council ordinance, just so we could be thinking about it before we have the draft next month?
Just email them out to us.
Yeah.
Send
Yeah,
You mean the
just
existing-
email us.
Yeah, what's
Yeah, the
already there?
existing,
Yeah.
sure, we've got that, we can send that out tomorrow.
We do fully plan on doing it. So when is that, when do you go across the street?
Not till January.
Probably December 31st at 11:59 p.m.
Did you get that, Clinton? Did you get that? That's on his time.
How many seconds was that?
Sometimes, yeah.
All right, man, are you ready for?
Oh, we don't, yeah.
This was not my.
Cindy, you talking about Cindy? She has a grandbaby. She just had a new grandbaby. That's why she's not here today.
I think I've seen it one.
No, she's been at Morton. But if you want them to bring her, I mean, whose job is that to be looking at the attendance? Make sure they're meeting our guideline?
Traditionally, usually when city council addresses appointments or reappointments in June or July, I think historically is when we've done that. Staff keeps a spreadsheet of all of our meetings, action items, developments that are approved, and attendance as part of that. And we would evaluate that to see if the minimum requirements are being met.
But the number's usually 70%, I think. It has been in the past.
Yes, sir.
Thank you.
Yes, and that,
Your travel's mustache.
Yeah, I'm calling Kettle Black here. Show Daryl his attendance record, and see what he thinks.
All right, you ready for a motion?
Sure.
I make a
Sure.
motion. It's fine.
I second that.
Motion by Jim, a second by Jeff. Any discussion? All in favor, aye?
Aye.
All opposed? All right, thank you.
You wanna come with, Will?
Yes.
I just,